governments to look at specific contracts and which sometimes require quotas or licenses before being able to conduct cross-border research and development and transfer of rights. Understanding what rights we're talking about when we do R&D in China is also very important. Inventions are not made by a company, they're made by people. People sit down and create or invent something, and the question is whether this something, once it is done, right at that moment is already right, which can be made subject to contracts. Actually it is, and therefore it's very important to understand that when activities start cross-border R&D in China, you need to be very much aware of that at the moment of creation, may be already a need to have a clear stipulation and a clear understanding who owns what. Basically, for inventions, at the moment of creation, you first have a right to the invention, but the patent application right, so you have not filed for a patent yet. The moment this invention is filed with the patent office, you will have a patent application right. And the moment it is granted by the patent office, you will have a full-blown patent right. For all these rights and distinction to be made for them, there are various contract models which allow to shift ownership at each stage. And at each stage, formality requirements and legal requirements may apply. This is much easier in the case of copyright, because copyright will come into existence according to international agreements and the Chinese copyright law at the moment of its creation. Copyright is often underestimated, but plays in an increasingly digitalized environment driven by software a more and more important role. Most contracts disregard how to deal with that properly, disregard problems related to moral rights, disregard problems also increasingly to the question of whether cultural law may govern certain copyright contracts. In all cases, right owners and contractual partners need to keep in mind that in the end, Chinese law will govern the question of whether a right comes into existence at all, whether a right is transferable, and formality requirements may apply to the transfer of rights, notwithstanding any choice of foreign law. Therefore, do not rely on a mere choice of law clause to say, I can run it as I'm used to in my country. There will be special and particular stipulations to have to be made to make sure that indeed all the transfers are successful. As outlined earlier, any transfer of patents or patent applications to a foreigner requires approval and registration by the Patent Office, but not only that, the Patent Office will not grant this registration and approval if there has been not compliance with another system for registration and approval under the TIER rules, the Technology Import and Export Administration Regulations. These procedures are separate, and these procedures are a mandatory first requirement before actual transfer of a patent application or patent right can be made. Patent applications, as earlier said, also need to be analyzed in advance before filing whether there is a need to comply with the confidentiality examination. So this TIER registration, when does it apply? What is cross-border technology transfer from a Chinese point of view? We have listed here the exact definition of the cross-border technology transfer as contained in Article 2 of the TIER regulations. And as you can see, this definition is extremely broad. It covers anything, not only assignment of patent rights or patent application rights and licenses or know-how, but also technical services and other types of technology transfer. This catch-all provision, therefore, has a very, very broad framework which it covers. And that means that even email transfer, data transfer, and things which are seemingly innocuous may fall under these regulations. Usually, these scenarios will apply, of course, in cases of licensing, in case of production facilities with new technical results, or in the case of sale of technology and IP rights. Now, under this TIER system, separately from the Patent Office system for transfer of right, there are three categories. Categories is defined, each category is defined by a catalog, a very exhaustive catalog, defining which technology areas some technology may not be imported or not be exported, where there are restrictions and prior approval is required, and where the technology in principle is free, but nonetheless needs to be registered with authorities after a contract has been concluded, usually within 60 days. Now, it's important to note that there is, in particular for high-end research, a strong need to comply with these catalogs, which are reviewed every 4, 5, 6 years or so. Currently, there is also a revision of the whole tier regulations going on quietly with MOFCOM. Now, if a contract is concluded and implemented in an area of restricted technology, the problem is that this contract as a whole will be invalid. Apart from other problems which may arise, such as technology smuggling and violation of administrative law, etc., one needs to be very careful in terms of ownership of rights, that this ownership is indeed given because the contract is valid. For restricted technology, therefore, usually the law will say that you first will have to talk to authorities before you finalize a contract. In practice, it will be the other way around, that contracts are negotiated, and once a full version is agreed on between the parties, it will be submitted to the authorities. In all areas, it is important to check very meticulously and to be careful not to be overconfident that a technology will not be restricted. Well, we have been speaking about free technology. Free technology is the vast majority of technology fields. People often ask, why should I even register? If I don't register, the contract is still valid, so I go ahead and I don't mind. In the past, this has been a universal practice, but that has changed strongly in the past few years, given an increasing attention by Chinese authorities on compliance by foreign and Chinese firms with administrative regulations and requirements under administrative law. In the past, this system was implemented by prohibiting remitting money, for example, license fees abroad, if no registration certificate could be provided. This rule has been abandoned in order to ease the burden of banks for checking, but in practice, still many banks do require contract copies and sometimes also registration certificates. Tax and customs authorities may also inquire, and the transfer of patent application rights, as outlined earlier, also requires this registration certificate. More important is the threat under lack of compliance with the foreign trade law and the need to avoid violation of administrative regulations. There are serious consequences in case of prohibited technology in particular. All the money related to the contract can be confiscated. A fine up to 5 times this amount can be levied on the parties involved. A foreign trade license can be lost, and further sanctions under criminal law may ensue. We have seen in our practice cases where people have underestimated these requirements and then ran into serious trouble, and we would advise even smaller companies to take a careful and measured approach. To give an example to everyone, here is the wording in the foreign trade law, which is partially mirrored then again in the technology import and export administration regulations. The most vexing result of an infringement is actually that the illegal proceeds will be confiscated and a fine up to 5 times will be levied on the players. Therefore, we advise for any type of cross-border activity to think in advance and to rely on more extensive contracts than we would, for example, in our European countries. When conducting and concluding, when negotiating and concluding a license agreement or a cross-border R&D agreement, there are further limitations which cannot be overcome, again, by choice of law. We have listed some of the most important limitations here in the presentation. The first and foremost often criticized rule is for technology import contracts that any achievement, any improvement on technology, on background technology provided by one party to the other must belong to the party making the improvement. Now, in many agreements, it is actually the other way around, that there is an agreement which gives the technology provider access to the entire results of the technology researched. This is also possible in China if the proper type of contract is chosen, but if there is just a normal license contract, this limitation will apply. Further required are mandatory guarantees for non-infringement of third-party rights and guarantee that the imported technology is complete, correct, effective, and capable of achieving the predetermined technological objectives of the contract. This should not be underestimated, and to write exactly and clearly in the contract what R&D activities are owed by which party, what the results will be, is very important to avoid any later on liability for breach of contract. Further monopolistic clauses, typically also known in Europe, for example, access, restrictions to third-party technology, raw materials, etc., are usually not allowed, and some other restrictions are only allowed if proper reason can be provided. Summing up the risk assessment, it's important not to rely on the choice of law, but to cross-check a contract or a project with the requirements under Chinese mandatory liability. It's also important to realize when IP is not solely developed, but developed with partners, because if no agreement is in place, usually the partner will own the IP or part of the IP. Even more important is any cooperation with state-owned Chinese partners who are subject to special rules under certain laws, which may grant certain compulsory licenses for use if the right owner does not later on use the research result properly or sufficiently in China. Again, commissioned and joint development and contractual stipulations will be the best safeguard to make sure that indeed the project will be safe for all parties involved. It's also important to realize that if government entities are involved, the rules may be modified somewhat. Coming to the end of the presentation, here's a brief checklist which tries to remind plans for R&D of the most important aspects. One is the R&D capability and environment. The capabilities are generally regarded as high, but one should not underestimate the time and resources needed to get to that point. So therefore, reliance on promises or on claims and statements made by a potential partner are usually worth little unless you have made a very good vetting of the true capabilities of your envisaged Chinese partners. Be careful also when it comes to taking up R&D incentives. The high and new technology enterprise status is very sought after, but requires a constant flow of patent filing. The requirements have recently been upgraded and made more difficult, and loss of that status later on may lead to the need to pay back tax benefits enjoyed. For the protection and use of the R&D results, it's important to realize whether your partner is subject to certain use requirements because it's a public entity. It's important to take into account the level of infringements and to be very cautious when it comes to know-how licenses, as these contracts require a much more extensive set of safeguards to make sure that the know-how license contract does not lead in the end to a know-how transfer and loss of know-how. Joint innovations are the way to go for most companies and do require good contracts which are not violating, for example, the prohibition of unilateral grant-back clauses and proper agreements on improvements. Employee inventions can play a huge role, for example, if American companies are involved, which usually are not used to the notion and the idea of having to pay extra money on top of salary for inventions made. It's also important to realize that under Chinese contract law, there are certain preemptive rights in case an invention is transferred, which need to be excluded properly to make sure that ownership still rests with the company. Finally, think about copyright and don't forget this important aspect of IP rights. Regarding formalities, the restrictions on transfer to foreigners must be known. The tier rules must be followed, including the contractual clauses and warranties required. And it is important to structure a contract in a way which makes the whole transaction safe also for the mid and long-term future. Finally, patent filing is increasingly becoming important in China. We strongly recommend filing inventions in China. When filing first in that country, be aware of that the practice of the Chinese Patent Office is less lenient as the USPTO and sometimes more difficult than the European Patent Office. So going through the confidentiality examination to be able to file a first application in the way you're used to may be worth the money and the time, and usually obtaining leave by the Patent Office is not difficult. We have come to the end of this presentation. Thank you very much for your attention. Do feel free to direct questions to me and my firm, and we will be happy to try to support you. And as always, the IPR Help Desk will always be a very, very good starting point for you to take up any questions or queries you may have. Thank you very much.
Thank you very much, Thomas, for a very informative presentation. I would now like to pass the floor over to Shirley, who will talk a little bit about applying for co-funding for Horizon 2020. So, Shirley, over to you.
Yes. Good afternoon to the Chinese participants and good morning to the EU participants. I'm Shirley Zhang from CICT. Actually, before I start my presentation, I would like to give a brief introduction about CICT. Actually, it was the CETR before 2 years ago that we changed the name to meet the requirements of the whole ICT supporting. Actually, CICT is the major supporting organization of MIT and also the Tyler Research Academy in ICT field in China. Actually, we also play the role in both domestic and international standardization, and also the test and the certification. Actually, we give support to and also deep involving the international cooperation on ICT. I think in ICT era, actually EU-China have a cooperation, long history that actually DG Connect has evolved into ongoing dialogue with China. One is with MIT, which is Ministry for Industry and Information Technologies. Actually, during the sixth dialogue meeting, that there are several important areas for cooperation, which is the 5G, IoT, and also smart city. Actually, there is also another dialogue with MOST, which is related to the presentation today, because MOST is the important ministry to supporting the RID program in China. Actually, these two dialogue is quite related to the R&D cooperation and supporting. Actually, during the ICT era, we had several important areas cooperation between China and the EU. The newest one is 5G. We all know that we signed the joint declaration in government level, and also the MOU between 5G PPP and the MT 2020 promotion group. And in 2011, actually, the EU-China IoT advisory group was established, and also the smart and green city cooperation was initiated in that year. And in 2010, there is the future internet, which is related to IPv6. So there are several important ICT areas if cooperation is ongoing. We know that at the end of last year, there first call for proposal under the EU-China Research and Innovation Cofounding mechanism published. Why I mentioned the true dialogue, because that is the effort of this true dialogue to establish the co-funding mechanism. We all know the background that before the co-funding published, that we will get funding from the EU project, and also some EU company can get funding from most project, but they are separate. There's no co-funding mechanism. For the co-funding mechanism, including the areas of agriculture, technology, ICT, space, aviation, energy, health, transport, water resources, also the energy saving and emission reduction, advanced manufacturing, new materials, sustainable urbanism, and the exchange of young scientists. It's nearly cover all of the topic and the Horizon 2020. Actually, most submit the call for this year. Actually, that the China-based entities that are successfully evaluated in Horizon 2020 proposal can receive the funding from most. So we can see that there is some precondition. So before you apply for the most funding, you must have successful evaluation from Horizon 2020. Actually, that from the most website, we can get some application details. Generally, the budget will be not over 5 million RMB project, and the period will not over 3 years. Actually, the China Science and Technology Exchange Center will give big support to the application. The application can be submitted to the Exchange Center. Actually, this year we just had a new application to the co-funding. When we have some questions, we just call the Exchange Center. The contact person will be very great help to explain your questions, the details. So please feel free to contact with the center. Actually, I think for all of the Chinese partners, if you want to get the funding from most, there need 2 phases. One phase is the Horizon 2020 application, which is the first phase. And in this phase, you need to work together with the EU partners to finish the proposal and to have some output and contribute to the application. And then if you got successful evolution, you will go to the next phase, which is the most phase. In this phase, you need to work together with all of the Chinese partners together to prepare the Chinese application together. So for my personal experience for the cooperation, that it's very important to have the good partners and have the interesting name. Here I give some example of the cooperation project between EU and China, which myself involved. Actually, the ongoing project is that EU-China study on IoT and 5G, which the short name is exactly. So you see there's a very good name and easy to remember, and exactly showing what's the objective of the project. Actually, this project has 14 partners, 8 from EU and 6 from China. Here, at least all of the partners, you can see they are from different countries of EU, and from they are also for the Chinese partners. They include the companies such as like Huawei, and also the academy like the China Academy of Science, and also academy which is CICT, and also you have the universities such as the DUPT and HUSC. So this project is still under negotiation. Actually, that we finished the proposal and get very good evaluation result, and now we are prepared the grant agreement together. And actually, there are also some other projects I involved during the past several years. The first one is Probe IT. Actually, this one is related to the Internet of Things. It includes the testing and the research and the survey on Internet of Things between not only China and the EU, and also the South Africa and other partners. So this will be give some roadmap of IoT. So the name is quite clear for the project. And another project is Choice. Actually, it also CIC project, Coordination and Supporting Action project. The Choice project provides the ICT collaboration between EU and China related to IoT, IPv6, and also other key technologies. And ECHL is another project. So this ECHL project, for the Chinese pronunciation, Qiao means the bridge. So it's quite good name for the application. So I think that if you want a successful application, so you need to choose the very good partner. They can work together and have their own output to the project, so which will make the project successfully and helpful to the collaboration. So for the co-founding project, you need to submit the application forms. There are two kinds of application forms. One is the basic information. So this basic information is quite short table. Will show with the title of the project, the partner, and the brief introduction of the project. And another form is the detailed proposal for the application. So I will to share the details because it will take some time for you to prepare the application for the Chinese partners. Actually, this form is quite familiar to the other application forms, which will include the title of the project, and also there will some description for the how to fill this form, and then there you will give some basic information and the output of the project. And here you will give some basic general information of the proposal in English. And then the budget for the project. And here is some the background and why you want to require for the funding for the project. and also the basic and the capability of the partners, the objective and the output of the project, and how to do the project and the working plan of the project. And then it's the result and IPR of the project. And you give both the introduction from Chinese partners and also the EU partners. So this is this detail of the proposal. So you need to spend some time on it. Actually, we check with the exchange center that all of the partners in the 2020 proposal should be submit the application as one team for the most proposal. Even you have 20 partners together, you need to just submit one application to the most proposal. So it means the budget will be shared all of the Chinese partners together. So finally, the application need to submit to the online system. Here I give the website of the online system. So that is the definition and my understanding for the co-funding application for most, because this is the first time for me. Hope is helpful, and I still cannot sure we can successful to the application, but I hope so, and I hope my presentation will be helpful to all of you. Thank you.
Thank you very much, Shirley, for some very useful insights on co-funding for Horizon 2020. So we've still got a few minutes left to open the floor, and if anybody's got any questions for either of the experts. One has come in, I think this is directed towards Thomas. So could you maybe say a little bit about tax or other requirements for transferring technological equipment for academic research in China?
Yeah. In general, tax follows its own systematic and categorization of which tax has to be paid. So equipment which is delivered from outside China into China does not have a kind of a special tax rate. There may be certain customs duties which can be exempted or can be paid on top depending on the status of the importer. But as regards tax, it will all depend on the underlying contract and type of contract. If it is, for example, a service contract, and there is only a certain type of remuneration for the services for shipping the machines into China for academic equipment, in that case, only the services will be subject to formerly business tax, now increasingly VAT, and there may be, to some extent, if there are further remunerations such as license fees payable, there will be a sort of withholding tax, which is nothing else than a payment of a corporate income tax in the form of withholding at its source by the authorities in China before the money is remitted abroad. So for the tax assessment of how much has to be paid, whether there is a better way, it depends strongly also on the type of underlying contract, not only on the act of shipping itself.
Thank you very much. And another question here for Shirley. Is it necessary then to submit first to EU Horizon 2020 call and then to most, or is it better to do it simultaneously?
Yes, I think from my understanding, it's necessary to submit the Horizon 2020 first. After you get successful evolution, then you can go to the next step for the most. And because for the most application, it's necessary to provide the agreement of the 2020 project. We need all the partners sign the agreement. So it means that the 2020 is the first step to apply for the most projects.
Okay, thank you. And where may people be able to find the list of restricted technologies?
Actually found on the website of MOFCOM in Chinese only. There is no English translation to my knowledge available. There have been some service providers translating older lists, but not the most recent one. And that makes the exercise of checking, it makes it necessary actually to have a Chinese speaker and then jointly analyze whether you fall under this list or not.
Thank you. And how much time should be reserved for applying for the co-funding mechanism, i.e. writing of the proposal and providing general information, etc.?
How much time?
Yeah.
Actually, I think it depends on the deadline for the co-funding application. For this year, the deadline is the end of July. So actually, that regards the result of 2020 project, I think it's at March or April of this year. So before. So we spend a half year to prepare the 2020 application, and then maybe 3 or 4 months to prepare for the most application. So totally maybe 1 year, because I think before you prepare the 2020 application proposal, you also need to communicate with EU partners together. I think it's similar like the application for project in China, that because there are also competition in the 2020 project, so there will be different proposal, there will be different team to work together, so you need to spend some time to keep contacting with the EU partner and to understand the requirements of the proposal, to meet the requirements and the objective of the proposal. So I think that 1 year will be the whole time. I will say maybe 1 year will be needed for the co-funding proposal.
Great, thank you. And would you be able to say a little bit about the evaluation mechanism from MOST?
Pardon me? The
evaluation.
The evaluation of from MOST is actually that I contact with the MOST that the deadline is end of July, and after that date, they will organize the evaluation of the proposal, and they will take some time. Maybe the end of this year, they will give the result of the evaluation.
Thank you. And what is the success rate of proposals that are approved by MOST in relation to the proposals that are submitted that comply the eligibility criteria?
Actually, I think it's difficult to answer this question for me, because that actually I think this is the co-funding. It was just set up from last year. It's not too difficult to tell the rate of the successful rate of the application. So for myself, I also want to know will it be successful, but I cannot get the result. So I think it depends. They also need to check the application. And I think another important thing is that you cannot just translate the English application version to the Chinese. So for my personal understanding, most give the supporting to the team. They also want to see the output, which will be meet the requirements of the China development of the ICT technology. So I think that it's better to finish the task or the objective of the 2020 project, and also will cover the requirements of the Chinese market, which will be better.
Brilliant. Thank you very much. I'm afraid we've run out of time for today, but I'd like to say thank you very much to both our experts, Shirley and Thomas, and also to all the attendees for your time and interest in both the China IPR SME Help Desk and DragonStar Plus. Just to remind you, this presentation will be made available for download in the coming days on our online portal under the events section, where you can also find full details of all the future Help Desk webinars and events. And yeah, thank you very much, and we hope to see you at future events.
Okay, thank you.
Thank you as well. Have a nice day and a nice evening in China.